You've heard it before. You have the right to 12 weeks of maternity leave. And you believed it. Because why wouldn't you? Maybe you even planned around it, counted the weeks, talked to HR, figured you had it handled. Here's what nobody told you. Those 12 weeks, your employer doesn't owe you a single dollar of pay during them. Not 1 cent. And if you work for a small company, we're talking millions of Americans, you may not even have the 12 weeks. The protection you thought you had is a shell. And here's the part that should stop you cold. It doesn't matter if your delivery was complicated. It doesn't matter if you had surgery, if you lost blood, if your doctor told you to rest for 6 weeks. In more than 35 states, none of that changes what your employer can legally do on Monday morning. Before this video is over, you'll know exactly what protection you actually have, and what to do with it, no matter which state you're in. Stay with me. Picture this. You're a few months out from your due date. You've done everything right. You talked to HR, you read the company handbook, you know you have FMLA, the Family and Medical Leave Act. 12 weeks, job protected. You did the math, you have some savings. You figured you'd make it work. What you didn't know, what almost nobody knows until it's too late, is that there are two completely different things that people call maternity leave. One is job protection, the right to come back to your position after you're gone. The FMLA covers that, for some of you. The other is income replacement, money coming in while you're home with your newborn, while you're recovering, while you're trying to figure out how to keep everything together. The federal government guarantees the first one, with conditions. It guarantees the second one for exactly 0 Americans. Not a single federal law requires your employer to pay you during maternity leave. And most people, including most HR departments, don't explain that distinction until you're already out the door. Think about what that actually means. You planned for 12 weeks. You might get 12 weeks of no income. And if you didn't save enough, or if something went wrong during the birth, that calculation falls apart fast. That's where we start. Let's talk about the FMLA. Because most people think they know what it is, and most people are wrong about at least one critical detail. The Family and Medical Leave Act was signed in 1993. It gives eligible workers up to 12 weeks of unpaid, job-protected leave for things like the birth of a child, a serious health condition, or caring for a family member. Unpaid, job-protected. Those two words don't mean the same thing, but they get blurred together constantly. Here's what the FMLA actually guarantees. Your employer has to hold your job, or an equivalent one, while you're gone. That's it. There is no wage replacement built into this law. None. Now, who does it cover? This is where it gets worse. To qualify for FMLA, you need to check 3 boxes. First, your employer has to have at least 50 employees. Second, you have to have worked there for at least 12 months. Third, you have to have logged at least 1,250 hours in the past year. That's roughly 24 hours a week, every week for a full year. If any one of those 3 conditions isn't met, the FMLA doesn't apply to you at all. And here's the number that should hit hard. Nearly 40% of American workers don't qualify. Not because they did anything wrong, because of where they work, how long they've been there, or how many hours they log. That's tens of millions of people, many of them in exactly the kinds of jobs where you'd expect the least cushion. Retail, food service, home care, small businesses. For those workers, there is no federal floor, no job protection, no income, nothing. And for the 60% who do qualify, remember, the law protects the job. It doesn't pay the bills. So what determines whether you get anything at all while you're home with a newborn? That answer lives in your state, and most people have never checked it. So now you know what the federal government offers, which is job protection, if you qualify, and nothing else. What you probably don't know is what your state offers. And that gap in knowledge is costing people real money. Here's the reality as of right now. Only 11 states, plus Washington, D.C., have active, mandatory paid family leave programs. Programs where your employer is required to participate, contributions come out of your paycheck, and when you have a baby, you actually receive a portion of your wages while you're home. 11 states out of 50. In roughly 38 states, your employer has zero legal obligation to pay you a single dollar of maternity leave. Zero. And most workers in those states have no idea that's where they live. Now, if you're in one of the states that has a program, that's not the end of the story either, because even those programs have eligibility requirements: minimum hours worked, minimum time on the job, a waiting period before benefits kick in. The program exists in your state, and you can still be left out of it. The point isn't to overwhelm you with details right now. The point is this: most people assume their state has something. Most people have never actually looked it up. And the difference between knowing and not knowing before you go on leave can be the difference between a manageable situation and a financial crisis. Here's what to do right now before anything else. Go to your state's Department of Labor website. Search paid family leave plus your state name. Find out if your state has a program. Find out if you qualify. Do it before the baby comes, because once you're out the door, your options narrow fast. And if your state doesn't have a program, which is true for more than 35 states, what your employer can legally do to you next is something most people never see coming. Hey, real quick. You just found out that the protection most people assume they have may not exist the way they think it does. And what's coming next is the part that most people never connect to their rights as a worker. If this is landing for you, if you're realizing there are things about your situation you haven't checked yet, subscribe to Law Drop right now. Hit the bell so you don't miss what's coming. And if this video is already changing how you think about this, hit the like button. It helps more people find this information before they need it, not after. Stay with me, because what comes next is the part that should have been in every prenatal class in America. Here's the assumption that almost everyone makes. Okay, maybe I won't get paid during leave, but if something goes wrong during the birth, surely that changes things. Surely my employer has to give me more time. No. In more than 35 states, a complicated delivery does not change what your employer is legally required to do. A cesarean section is abdominal surgery. Your surgeon cuts through skin, fat, muscle, and your uterus. The American College of Obstetricians and Gynecologists recommends recovery monitoring for up to 12 weeks. You leave the hospital 2 to 4 days later, still recovering from major surgery. Postpartum hemorrhage affects roughly 1 in 50 deliveries, according to ACOG. It is one of the leading causes of maternal mortality. Women have lost significant amounts of blood, been hospitalized after going home, and still been expected back at work within days. A Human Rights Watch investigation documented exactly this. A woman we'll call Hazel suffered a hemorrhage from a retained placenta 6 weeks after giving birth. She lost a third of her blood. She was back at work 1 week later. Not because she was ready, but because she'd already used her paid sick leave and couldn't afford more time without pay. There's also the factory worker who had a high-risk breech delivery. The day after she got home, HR called, not to check on her, to ask if she could come in that weekend. That call was legal. Now here's what most people don't realize. There is a complication that affects far more women than hemorrhage, one that develops in the weeks after delivery, and that almost nobody connects to their rights as a worker. According to the CDC, about 1 in 8 women experience symptoms of postpartum depression after giving birth, and diagnosis rates nearly doubled between 2010 and 2021. This isn't the baby blues. It's a clinical condition: severe anxiety, inability to bond with the baby, inability to function. It can last months. And studies show consistently that longer maternity leave reduces the risk. More time at home, lower risk. Financial pressure to return early, higher risk. Which means the states that refuse to guarantee paid leave aren't just leaving workers without income. They are creating documented conditions that make a serious medical complication more likely. Here's where the legal dimension becomes cruel. A woman we'll call Diana, documented in a Human Rights Watch investigation, developed severe postpartum depression after giving birth. She felt disconnected from her own baby. She needed treatment. She tried to use her remaining paid sick days to get help. Her employer threatened to fire her. She never sought treatment. A woman in a medical crisis, the only tool available to her, a handful of sick days. An employer who faced no legal consequence for threatening her job. In her state, that was allowed. And the women who carry the heaviest burden of this are not distributed randomly. There is a pattern, and it isn't an accident. Only 27% of private sector workers have access to paid family leave through their employer. But that average hides everything important, because access is not evenly distributed. Among the bottom 10% of earners, only 6% have paid family leave. 6. Workers at the top have access at rates 10 times higher. Those bottom earners are working in restaurants, retail, home care, warehouses. In food service and construction, access rates fall below 12%. These industries employ tens of millions of Americans. And in more than 35 states, those workers have no state program either. Now let's talk about who carries the weight beyond the financial. According to the Center for American Progress, approximately 1.1 million Black women need family or medical leave in a typical year, but don't take it. Not because they don't need it, because they can't afford to go without pay, or fear losing their job if they try. Those foregone leaves cost Black women an estimated $3.9 billion in lost wages annually. According to CDC data, Black women die from pregnancy-related causes at rates roughly 2 to 3 times higher than white women. And the workers with the least access to paid leave are disproportionately the same women facing those elevated risks. This is not coincidence. This is what a system looks like when it was never designed with these workers in mind. And the employer who can call Monday morning and say, "Come back or don't bother," is operating completely within the law in more than 35 states. So where does the line actually sit? Let's be precise about this, because the line between what's legal and what isn't is real, and knowing where it sits changes what you can do. What your employer can legally do in most states. They can require you to return to work at the end of your leave period. They can decline to pay you anything during that leave. They can temporarily fill your position while you're gone. If you don't qualify for FMLA, if you work for a small company or you haven't been there long enough, they can let you go entirely and face no federal consequences for it. That's the legal reality for tens of millions of American workers. Now, here's where the line sits. What your employer cannot do in every state, regardless of size. They cannot treat your pregnancy or your postpartum condition as a reason to fire you, demote you, or cut your pay if they would not do the same to another worker with a temporary physical limitation. That's the Pregnancy Discrimination Act. It applies to employers with 15 or more employees. It's federal law, and it is separate from the FMLA. If your postpartum complication, a hemorrhage, a serious infection, a surgical recovery, rises to the level of a disability under the Americans with Disabilities Act, your employer may be required to provide reasonable accommodation. That means modified duties, a temporary schedule adjustment, or extended leave, depending on the situation and the employer's size. And if you do qualify for FMLA, your employer cannot retaliate against you for using it. They cannot demote you, cut your hours, or create a hostile work environment because you took protected leave. That retaliation is illegal. So what should you actually do before you go on leave? First, get everything in writing. Your leave start date, your expected return date, any agreement about your position, your duties, your pay upon return. Email is fine. What matters is that there is a written record that both sides can refer to. Second, if you have a complication that extends your recovery, tell your employer in writing. Don't just call in, send an email. State the medical reason in general terms, you don't have to disclose everything, and request an accommodation or extended leave in writing. This creates a record that is essential if the situation escalates. Third, if your employer violates the Pregnancy Discrimination Act or retaliates against FMLA leave, you can file a charge with the Equal Employment Opportunity Commission. There are time limits, typically 180 days from the discriminatory act or 300 days in states with their own anti-discrimination laws. If you wait too long, you lose the ability to file. Fourth, if you believe you've been discriminated against, contact your state's Department of Labor and consider consulting an employment attorney. Many offer free initial consultations. Many work on contingency, meaning you pay nothing unless you win. The system is stacked against workers in more than 35 states, but knowing exactly where the legal lines sit and documenting everything on your side of those lines is the difference between having options and having none. And now that you know what the system actually offers, here's what to do with that, depending on exactly where you are. Before I give you the specific steps, I want to be clear about something. Every situation is different. Laws change, and nothing in this video is legal advice. What I'm about to give you is a starting point, not a substitute for talking to an employment attorney about your specific situation. That said, here is what you can actually do right now, depending on where you are. If you are pregnant and you live in a state without a paid leave program, which is true for more than 35 states, your checklist starts here. 1. Find out if you qualify for FMLA. Your employer needs at least 50 employees. You need at least 12 months on the job and 1,250 hours in the past year. If you check all 3 boxes, you have 12 weeks of job-protected unpaid leave. That's not nothing. Your job is protected. But plan for 0 income during that time unless you have another source. 2. Ask your HR department if your employer offers short-term disability insurance. Many do, and in most states, pregnancy and postpartum recovery qualify. Short-term disability typically replaces 50 to 60% of your income for a defined period. It's not paid family leave, but it's something, and most workers never ask. 3. Get your leave agreement in writing before you go. Dates, position, return conditions. Email is sufficient. What matters is the record. 4. Know the Pregnancy Discrimination Act exists and applies to you if your employer has 15 or more employees. If something goes wrong, if you're passed over for a promotion, demoted, or let go in circumstances that look connected to your pregnancy or postpartum condition, that law is your starting point. If you live in a state that has a paid leave program, California, New York, Colorado, Massachusetts, Washington, Connecticut, New Jersey, Rhode Island, Oregon, Delaware, Minnesota, or Washington, D.C., your checklist is different. Find out your state's specific eligibility requirements before you go on leave. Each program has minimum hours, minimum earnings thresholds, and sometimes a waiting period before benefits begin. Don't assume you're covered, confirm it, and file your claim before or immediately after your leave begins. Most state programs have windows for filing. Missing that window can mean losing benefits you were entitled to. Now, one state deserves specific mention. Colorado is the only state in the country that offers paid leave for parents whose newborn is admitted to a neonatal intensive care unit. Starting January 2026, parents in Colorado can receive up to 12 additional weeks of paid FMLA benefits when their baby is in the NICU. No other state offers this. If your baby is born prematurely or with a condition requiring intensive care and you live in Colorado, That protection exists for you. If you went through this without knowing your rights, if you returned to work before you were ready, lost income you didn't know you were entitled to, or faced pressure from an employer that crossed a legal line, it may not be too late. For FMLA retaliation, you have 2 years to file a complaint with the Department of Labor, 3 years if the violation was willful. For Pregnancy Discrimination Act violations, you have 180 days to file with the EEOC, or 300 days if your state has its own anti-discrimination law. Time limits matter. If you think something illegal happened, don't wait. You came into this video thinking you understood how maternity leave worked in America. You're leaving it knowing something different. Not that the system is broken, you probably suspected that, but exactly where the breaks are, exactly what you're entitled to, and exactly what to do about it. That's the difference between information and protection. There is a woman in your life who is counting the weeks right now. She's done the math. She thinks she has a plan. She doesn't know what you just learned. Share this video with her, not because it's interesting, because it could change what happens to her when she walks back into that hospital and when she walks back out. If this video gave you something real, hit the like button, subscribe to Law Drop so you don't miss what's coming next, and hit the bell, because the next video is the kind of thing nobody tells you until you're already in the room where it happens. Leave the word "protected" in the comments below. If you came in here thinking you were covered, and now you know the answer is more complicated than that, let us know. You're not alone. And speaking of rooms where things happen without you realizing it, next time we're going inside the emergency room. Because when you arrive at a hospital in a crisis, there's a document they hand you at the front desk. Most people sign it without reading it. And what's inside that document may affect your rights in ways you won't find out about until it's too late. That's the next video. Don't miss it. This is Law Drop. Know the laws they hope you never find.